Good afternoon, Svitlana. Welcome at the second stage of the selection process to the HQCJ. The selection commission is holding the interview in its full composition, and the members are Zazhachny, Ivan Mishchenko, Evgen Mezentsev, Serhiy Verlanov, Steven Markman, and Robert Brugheisen. The rapporteurs are Evgen Mezentsev and Zazhachny. So, Svitlana, in case our interview is interrupted for technical reasons, the Commission will definitely reach you and reappoint the interview for the other date and the other time, and the interview will continue from the place where it stopped, in case this happens. During the interview, the members of the Commission will ask you questions. Please give concise answers to the questions, and the member of the Commission asking the question shall be entitled to limit the time of your answer. Before the interview, you will have a chance to do self-presentation in order to tell about your motivation, your ideas, and why you have decided to apply for this position. So that's all for me from the point of view of the introductory remarks, and let me give the floor to the rapporteurs, to Yevhen and Ted. You're welcome. Thank you, Mr. Chairman. Good afternoon, Svitlana. I'm Evgen Mezentsev. And let me start, since I'm going to be the key reporter at your interview. So let me start with a small introduction. And let me start with telling about your qualities and your competences, which, in our opinion, do correspond to the law for you to be able to participate in the competition. So this is Olenenko Svitlana, the previous maiden name Hlivna, and she was born in 1978, and now she's the head of the Analytical and Statistical Department of the Commercial Court of Cherkasy region, and she has been working in this institution since 1999 for quite a period of time. As you can see, 24 years already, or 23 years. And she's been holding this position, the head of the Analytical and Statistical Department. So she's been holding this position since 2007. She's got higher legal education in 2005. She graduated from Kyiv National University, named after Shevchenko, law faculty. According to the data from CSOs and from NABU and National Agency Corruption Prevention, there is no special data about her, no claims. And besides that, Svitlana is one of the few candidates who provided the documents with the translation into English. Her work experience is 23 years. This is general experience, and in the field of law it is 16 years. She has a command of Italian. She also has a command of Ukrainian, has got the certificate of the second degree. The certificate dates the 23rd of February 2022. She's got a good motivation letter, well-structured, concise, easy to digest. She's a certified trainer of the Pravo Justice Project. She is lecturing and having different articles in mass media and Zakon Business in particular. She's got references from 2 scientists from Cherkasy and 1 priest. So this is a short presentation. And now, Svitlana, the floor goes to you for you to express what your motivation for the participation in the competition is. Thank you for an opportunity provided to me. So I'm Olenenko Svitlana. I've got the diploma of Kyiv National Shevchenko University, Law Studies diploma. I worked as in court for 23 years, but now I have already left court. So I worked as a consultant, as the head of the Analytical Statistical Department, as assistant judge, legal counselor, and for a period of time I was writing texts of court decisions when I was assistant judge. As the head of the department, I have been dealing with the development of the judicial dossiers, organization of meetings of judges, and bringing the standpoints of the Supreme Court and European Court of Human Rights to the notice of judges. I was also dealing with the organization of the library and looking for different materials of procedural nature for judges. also dealt with the statistics and accounting of the cancelled decisions. I also registered claims and analyzed claims against actions of judges. I have got experience of working in the selection commission dealing with hiring of people to civil servants positions. For me, participation in this competition is the opportunity to go to a higher level of my professional activity. I've got publications in well-known editions. I participate in public campaigns, public events, and always, when offered, I give positive response to participation in different events, including students, involving students. I'm ready to be a public person, and I think that the requirements for the applicants for judicial profession should also include the social responsibility. I've had this social responsibility. I've got good legal background. I have got experience of working as a judge, and this helps me this will help me to improve the quality of the judiciary, of justice, and that is a very important demand in the society now. Are you sure? Okay, thank you. Let me point it out right away that within this selection, we have a lot of well-known, distinguished lawyers, and normally we get people who systemically, several times, try to participate in some selections and become members of some top authorities. With you, this is, as far as I understand, the first attempt, the first experience of participating in such a competition. Am I right with this? Well, I understand that the level of this competition is really high. I used to participate only several times in the competitions for judicial positions. I opted for working in courts for myself long ago. And I think that it's important to keep to the principles of political impartiality, independence. And I'm very much willing to become a member of the HQCJ because I not only want to develop my career, to grow in my career, I also want to work in the field where I'm knowledgeable, where I'm an expert, where I worked for many years, where I spent a lot of time doing analytical studies, and I can really draw good analytical opinions and conclusions from the data I get. Clear. In your motivation letter, you have mentioned that you participate in the development of judicial dossiers, but normally the HR department deals with that. So what exactly would you like to improve in the procedure of development of judicial dossiers? Do you think that the information added there is really enough, sufficient, or probably it should be expanded? Judicial dossier is really developed by the HR department, but the information about the number of disputes considered, about the quality of dispute consideration and hearing is provided by the analytical and statistical department. So that presupposes joint work of several units of court. I don't mean that this is only my responsibility. That is all done in collaboration. Okay, let it be, but where do you see the need for any improvements in terms of development of judicial dossiers? Because actually the HQCJ is to develop the procedure for development of judicial dossiers. So if you become a member, you will be in charge of this procedure in a way. So how would you improve it? I think that judicial dossiers should contain some more information about judges, to get a full picture about the load of the judge and the efficiency of his or her work. I mean that it's necessary to highlight what the quality of his work is, like the number of cancelled decisions and decisions left unchanged. That is the duration of the timeline of case hearing. That is the number of stopped cases, adjudicated cases, adjourned ones. And also, I think that this is in a way an obstacle on the way to getting access to justice. And as far as the text of decisions are concerned, I think that it's necessary to change, not to count the number of days. I mean that, for example, there is 300 days in one court per year. That is the number of days of delay. But that's the figure that doesn't show anything. There should be some correlation. There should be some ratio. So we should see whether it's a problem or it's not. And we should also indicate the information about backlog, about the participation of the judge in courts of arbitration or in mediation, because this is something positive. If a judge acts as a lay judge and can really, or a justice of peace, and can bring people to an amicable, peaceful dispute resolution, this is a good judge. Also, we should take into account presumption of innocence and objectivity and subjectivity. When there is no proven bias in the judge's behavior, there is no proven interest on behalf of the judge, there can be no self-recusal. So you mean that sometimes the decisions on self-recusal are ungrounded? Yes. Yes, because we don't have the procedure for appealing self-recusals. Yes, that's what I mean. There is no procedure, but actually that could be a very good indicator showing us what the attitude of this judge to the team, to the other judges is. If such self-recusals occur on a regular basis, and if these are ungrounded recusals, the article about self-recusals clearly gives the list when the judge may announce a self-recusal. But I know examples from life when a judge writes a lot of self-recusals, and in that way he's trying just to shift the responsibility onto others. Of course, we do have this problem, and it's not yet settled. We really have such a trend among some judges. But how are you trying to improve this procedure? What is your solution? Because the decision of the court on self-recusal is the court decision that is binding, and it cannot be appealed. So what is your suggestion for improvement of this procedure? I'm sorry, Svitlana, for interrupting you. So how do you suggest we should improve the procedure? Should there be an appeal for self-recusal or what? No, I'm talking about the information we're going to include into the judicial dossier. If there is an indicator like that mentioned in the judicial dossier, and the judge knows that when his further work is assessed, this indicator will be taken into account, he will probably not announce that many self-recusals. But in particular, when he knows that after 5 years, 5-year term, he will have to be reassessed. But now we don't have 5-year terms, you know. Yes, I know, but I just mean that at some point of time, the HQCJ must have a look at the indicators showing whether the judge is scrupulous in performance of his duties or not. Because the norms are well prescribed in the legislation, and we know that systemic or gross violation of the functional duties of a judge constitute the grounds for dismissal. But this norm does not work. There is no mechanism for. So you mean that the HQCJ is actually entitled to get the competence for the revision of the legitimacy of decisions on self-recusal? This is not a procedural decision. No, I don't mean that. I agree with you. This is not a procedural decision. what I mean is that this is the general indicator, the information about which could be put into the judicial dossier together with other indicators. And I would also include into the judicial dossier the number of decisions of the European Court. It's actually there and should be still there. So the decision of the European Court of Human Rights and the cases heard by this judge. And I would also add the rate of enforcement of decisions of this judge. This would actually compel the judge to write decisions that are realistic, written in simple language for people to find it easier to enforce these decisions. And then we would also need political will of the legislators to affirm such proper level of control over enforcement of decisions. We have this mechanism declared in the Constitution in several words and in the codes, but there is no duty of the court to exercise this control. Well, okay, but don't you think that this is just shifting their responsibility, shifting a certain function of the executive authorities onto the court? How could a judge be dependent on whether his decisions that are supposed to be enforced by the executive services are working efficiently or not? Just means that judges would be dependent on executive authorities, on enforcement bodies. Don't you think so? Well, yes, to raise the level of trust in the judiciary, we must have higher level of enforcement of decisions, court decisions. And of course, we cannot be demanding this from the judge. For this, we have the special state executive or state enforcement service and private services. We do have special services for that. But if we speak about the general direction, vector of our reforms and the direction in which we are moving, that would be about the judge having such duties, for him to have the grounds for exercising such control. Okay, so let's stop discussing the issue of enforcement, because this is a topic that may well be discussed for some 12 hours. You have mentioned that you have inspection and control, you are in charge of inspection and control of the timeliness of procedural decisions and the timeline for their passing. So what do you think? Is the practice we currently have in the judiciary concerning continuation of the timeline of case hearing not for 15 days, the way it is stated in some codes, for example, commercial court or administrative court proceedings code, but for a reasonable period? Do you think that this would be a violation of the procedural timelines or not? I think it would be a violation of procedural timelines. And besides that, the period of case hearing is also influenced by the adjourned cases. We get this figure from the report about the judge, and we also get this indicator about the court in general. And sometimes we may not guess why the figure is so bad. For example, last year, there was some cases, they were considered and all the decisions were sent out. Why is the indicator so bad? That's because the program shows us the truth, shows us the backlog, shows us all the cases the judge has had since the moment he was appointed. And we get the indicator on the basis of the number of cases that have been suspended, adjourned. And this has a negative effect not only on the figures of this judge, but of the court in general. Okay, Svitlana, in your motivation letter, you are expressing the idea that there should be some analysis made of the so-called marginal threshold of canceling. What do you mean by that? Do you think that if a judge has the ratio of 20-25% of cancelled decisions, do you think that this is critical and the judge should be dismissed because of this indicator? What did you mean by this threshold, by this marginal limit of cancelling? Well, yes. The point is that I've been analyzing this criteria for this indicator for quite a period of time, and I don't see any logical completion of this process. We definitely need to have this red line, to have this threshold. And when the level of cancelled decisions is approaching this red line, we should already see this red flag. For example, the average figure is 4% of cancelled decisions. Well, the deviation could be 5 or 6, but if it is 7 or 8, then the judge should have a look at what case categories, in what case categories decisions have been cancelled, and he could probably undergo some training or spend more time in considering those case types. But if the percentage is 10%, the judge should be sent to the National School of Judges for advanced training. But if this indicator, this figure is 25, so probably this judge is corrupt. Okay. Do you think that the number of cancelled decisions points to the level of corruption? Is it so or no? Well, no. This shows how he perceives the rule of law. Okay, let's assume there is some specialization in court, and the judge of a commercial court considers cases on lease and some banking law. The cases are typical and conventional, and for example, 50% of cases are related to credits. So he hears them following the norms of the law, but there are some controversial issues there, and he just has so he adjudicates the case, and the Supreme Court, the Grand Chamber, passes the opposite decision and develops the practice, which does not correspond to the practice this judge applied last year. And via the appeal instance, the judge gets 45% of cancelled decisions in this case type. So should this person be considered to be a corrupt person, and should this judge be dismissed because of a great number of cancelled decisions? Well, you're right about this problem. We need to ask the Supreme Court to work in this direction to somehow reach one common legal point of view. Yes, but how could we ask? Every judge of the Supreme Court is independent. You cannot persuade a judge of the Supreme Court to pass this or that decision. How are you going to ask them? Well, we have the procedure of different judicial practices that are passed to the Grand Chamber. And during this procedure, we may really have the situation you have illustrated. That is the problem, but I would not say that this is a major problem, that it really affects a lot of cases. But the Supreme Court should understand that they are introducing elements of chaos into commercial relationship, into social relationship, and into the they are interfering with the statistics of cancelled decisions. Let me give an example. A judge asked me to find some examples from the practice of the Supreme Court on the dismissal of CEO, whether it's a labor dispute or commercial dispute. And I found two decisions of two different panels of the Supreme Court with two different opinions. Well, I know this, but sometimes the practice of the Supreme Court really shows the differences, because we cannot coerce the judges of the Supreme Court to pass certain decisions. That's their right and their will, and that is their internal feeling. Okay. Concerning your property, as I've mentioned, there are no specific problems with that raised by the anti-corruption bodies or CSOs. But along with that, let me clarify some information. In 2017 up to 2021, you mentioned that your former husband is still the member of your family. It was mentioned so in the declaration. Why? I did not indicate him as a member of the family, but I showed a different type of relationship, because when I was filling out the declaration, just technically, The form of the declaration indicated me to mention only co-owners of my housing, of my apartment, because after divorce, he was still the co-owner of the part of the apartment. We divorced. He is not living in that apartment, but he still has a share of the apartment in his ownership. That's why I have to indicate 3 co-owners. Is it a privatized apartment? The acquired one, the bought one. And I have to show all the 3 co-owners of the apartment, and otherwise the form of the declaration just will not be submitted. The point is that you have not been residing with your husband for 3 years, but you still have to reflect that. Probably it would be easier to settle the problem with the share of the apartment, just not to create this type of problems for you with the filling out of the declaration. You're absolutely right. Theoretically, that was possible, but to do this in life, I would have to pay him the share of property. And actually, I don't have enough money to pay for the share. My apartment is not that costly, but anyway, I don't have the money, and I didn't have the money to pay him for his share. In 2011, you mentioned that you bought a land plot for 700 square meters, but you did not mention the value. That was in the village of Rotmistrivka. So was it privatization, or you said that the value is not applicable? No, this is the land plot on which the house is located, the house where I was born, the house where my mom lives. And it so happened that the father was making a will, and he indicated 3 people, me, my brother, and my mom. We accepted this heritage, but mom ordered the documents, production of the documents for registering private ownership. And it so happened that this land plot is actually registered as joint property of the 3 of us. No, in fact, I never insisted on that, and I think that this is my mom's house, and I have my own apartment. Okay, Svitlana, so far that's all from me, and let me give the floor to my colleague, Ted.
Thank you. Ms. Olenenko, I want to understand a little bit more about your work in the law and your work history. From the biography that you have supplied to us, I see that you worked for 4 months as a juris consultant at A.T. Smila City, Smila, Cherkasy region, and then you worked 3 months as a juris consultant for VAT. After that, you worked for approximately 3 years as a specialist with the Arbitration Court of the Cherkasy region. Now, can you tell me a little bit about what work you did as a specialist with the Arbitration Court?
Well, while working as a specialist of the arbitration court, I had to deal with the preparation of draft decisions of the court, writing them. I participated in the court hearing as a listener and the observer, and then I helped the judge to produce the full text of decisions.
I see, all right. And then you spent approximately 5 years and a few months as a judge's assistant in the Commercial Court of Cherkasy, where you are now employed, of course, as head of a department. And we well understand from other candidates who also had the same career path, the work of a judge's assistant. However, it seems to me that at this point in time, you would have worked as a specialist, which really is, as you describe it, an assistant in the arbitration court, and then you worked as an assistant for 5 years at the commercial court. And I'm not sure I understood your introductory comments. Did you tell me after that you applied to be a judge on a number of occasions, or did I misunderstand you?
Yes, let me try and explain. That's true. That is the same court. In fact, the arbitration court and the commercial court is one and the same court. It was reformed. The name, the type of the court was changed. So the arbitration court was transformed into the commercial court. And my duties included preparation of text of decisions, and I had to find the regulations and the laws that were to be applied in specific disputes. And I also collected statistical data on those cases. And you're right about my duties. Both when I was a specialist and I was assistant judge, well, I had similar duties. And we didn't have the position of the secretary of the court hearing. These duties were also performed by assistant judges for quite a period of time.
Right. But did you, after your career as an assistant judge, did you apply to be a judge?
Yes. That's true, and I participated in such competitions to hold a judicial position for 3 times.
I see, and I take it that was not successful.
No, it was not a success any single time. And the last time, when I took the exam, I didn't get the necessary number of score. I got 69 for all the questions which we were asked. And let me mention that this procedure was not absolutely fair in relation to the participants, to the applicants who were applying for the judicial position, because over the same period of time, the qualification assessment was taken by judges, and the judges who got the same score as I did still went back to their judicial position and kept working. And I and my colleagues who got the same score got back to our position and did not go to judicial position, so it's not quite fair.
All right. How many judges are there in the commercial court of Cherkasy region?
Currently 12.
All right. And you are the head of a department, and you describe it as the Division of Analytics and Statistics. Is that correct?
For quite a period of time, I worked as the head of the Analytical and Statistical Department of the Commercial Court of Cherkasy region, but because of the war, I actually left the job.
And
currently, I do not work in court.
I see. When did you leave the job?
Last year. That's why in my documents I write that I'm the head of the Analytical and Statistical Department, because that is my last job. And I actually indicated this in my documents, that this is my last place of work.
I see. The way I read your biography, you claim to work at the commercial court until June 10th of 2022. And so you have not worked at the court since that time.
Right, you are.
All right.
That was exactly the date when I left the job.
I see. And as head of the Division of Analytics and Statistics, were you the senior administrator of the court?
Well, I would say that my position was among the top management positions. And I think that I actually was one of the founders of this unit, of this department. I was there at the beginning when it was founded. I organized all the work and I arranged the procedure of controlling all the documents, because when the decision is canceled, this case is given to me, the documents are given to me, to my department. So I established the procedure for this department. I was actually among the founders, so I think that this is my contribution. We always need to know where the materials are, in what unit, and who is responsible. So it's necessary to establish this procedure to always be in control.
Yes, and I understand that, but I want to understand better the level of your responsibility and how broad your experience was in respect of this court. Do I take it then that you were not the senior manager, the most senior manager, in other words, the boss of the administration?
I'm sorry, there are some problems with connection.
Yes. All right, I'll repeat my question. I just want to understand the level of your involvement and experience. You were the head of this statistics department, but was there a more senior administrator responsible for all of the work of the administrators?
Of course, this is chief of staff. Chief of staff was senior than me.
I see. Okay.
That is the boss in terms of administrative positions.
All right. Thank you. You had, in your motivation letter, you tell us that you have experience in identifying problems in the judiciary. And are those the kinds of problems that you were discussing with Judge Mezentsev? Or are there other problems that you have noted in the judiciary by your work in the court?
Well, for example, I have an article in the Zakon and Business newspaper, and this is the article about the mechanisms of judicial control, about the need of which I have been talking. This is also the problem that in the Code of Commercial Procedure, there is the norm that allows the judge to put a ban on the debtor for him not to be able to to go abroad. But there is no norm that would regulate the issue of removal of that ban. I mean, of lifting that ban. I mean that there is a debt, there is a ban on the debtor in the peaceful times, of course, not in wartime, not under martial law. But there is no mechanism for the judge to lift that ban. There is no article like that in the law, in the code, and this is actual limitation of freedom of movement of people. And the judge has to be looking for some norms, for some other analogies in order to somehow apply the law and to pass a logical decision. Also, there is an article I have written on the state judicial administration and its control over sending the decisions to the Unified State Register and placing a tick here that the decision has come into legal effect. I wrote this article rather long ago, but there I pointed to the problem consisting in the fact that this is not the most efficient, the most important figure showing the efficiency of the judge's work, because the period, the timeline for generation of the decision is much more important, because on the basis of the decision, the party can exercise its right to appeal. And beside that, I eliminate a lot of, I cover a lot of problems, like sending the appeal via postal channels. Well, that is a bad mechanism, and lawyers are dissatisfied with that, and the society in general is dissatisfied with that mechanism. So a lot of people are addressing court to protect this right. I mean, the judge must pass a decision, but on the other hand, the judge cannot issue this order after the appeal is over, because the appeal is still on the way. It's still being sent by post, and it's on the way. And
all right,
if,
Ms. Olenenko, what I think I have an answer, and I think I understand some of the issues that you have identified as problems. I'm going to turn the matter over now to my colleague, Mr. Broekhuizen, and he will have some questions for you as well.
Thank you, Ted. Ms. Olenenko, you describe yourself in the motivation letter as someone who is honest and independent and incorruptible. Of course, you know that, let's say, there are quite some reports that allege that there is corruption in the judiciary in Ukraine. What are you going to do about that when you would be elected in the HQCJ?
I will be demonstrating zero tolerance to corruption. I worked as an assistant judge, and I can tell you that I'm proud of this experience, because I was working with a judge who never accepted any kind of influence from any politicians or local authorities who were calling her, trying to influence her decisions. That judge never accepted any offers of that kind. And she always reported of such influence to the High Council of Justice. This is the type of behavior that I consider to be correct. This is behavior that demonstrates integrity. And for this very reason, I was working with that judge, because she had integrity.
But I understand you have also seen other behavior, is that correct?
I can be proud of the fact that I was working with two judges. I was assistant to two judges, and I never witnessed any kind of corruption. But I was surprised when once I received a phone call and I was being asked to influence the outcome of the court hearing. So I was trying to understand why I even received that phone call. I was so surprised. Was I having that kind of reputation, or was my court having that kind of reputation? And I try to convince people like that who come up with these offers, but I was upset with the answer that I received, because that person told me, well, I will call somebody else then. Maybe this is a stereotype that people cannot trust the courts, and that's why you may receive these types of phone calls. And the reason why I applied for this selection is that because I can tell you for sure I was never involved in any kind of corrupt actions.
Okay, let's say that you are elected in the HQCJ. Let's say that you're one of the members and there's a new president of the HQCJ who's an extremely important, well-established scholar, famous lawyer in Ukraine. And you would notice that he would be taking a bribe. What would you do?
I would report to law enforcement authorities, that's for sure. This is what a person with integrity would do.
And what would you do if you would be called by a minister from the government who would say to you, it's very important for national security that Mrs. X is appointed as a judge?
I would behave in the same way. It doesn't really matter how important that caller is. So if a person is honest about small things, if I didn't respond to any kinds of offers from my colleagues, and I mentioned that in my motivational letter that I participated in the work of selection commission within our court. And it's important that I've acquired some kind of skills. I was involved in interviews with the candidates, and there is the other skill that I have. I do not respond to those requests of helping someone. And I also don't really respond to any kind of negative information that I receive about candidates. I have critical thinking skills, and when I received any kinds of offers or requests, I told one of my colleagues that let us pretend that this conversation never happened. So if I receive some negative information about a person, it's up to me to make the conclusion about that person, and it tells me more about that person who is providing me with negative information than about the person, about who the information is, because that's the person who is trying to influence me.
Clear. Just my last question, but just because I'm interested. How did you learn? Because I understand that you wrote the letters to us also in English. And I understand you also speak Italian. How did you learn this? Are there any more languages that you speak?
Thank you for the question. I speak Italian because I've been studying it for a long time and I like this language. My mother moved to Italy many years ago. She was a labor migrant. She traveled there to find a better job, and then she got married there, and her husband is an Italian, and out of respect for him, I've been studying Italian for many years. And we had some language courses in the neighborhood, and I offered that my kid and I attend the courses together to learn some Italian, to spend some time together, because the kid was growing up and I wanted to spend more time with her, and together we completed the language course. But it's about me liking the language. When we talk about English, unfortunately, my level of English is not that good. So I had to ask for help. I had to ask a translator to translate my documents into English.
Okay, thank you. Justice Mark.
Ms. Olenenko, thank you for your participation in the competition here. In my judgment, your motivation is very thoughtful, and your background is, your professional background is very impressive, but it is unorthodox, you have to acknowledge. Help us understand just a little bit how you can make a contribution on the HQJC by contributing from the breadth of experience that you've had as a judicial administrator. I think any judge who's ever been a judge has understood the importance and the complexities of being a judicial administrator. But help me understand exactly how you think your contribution would be most deeply felt if you were to be placed on the High Qualification Commission, please.
I think that my experience of working in the selection commission for the selection of civil servants could come in handy because I was involved in all the stages of this selection. The testing was organized via computers, but I was preparing some questions. I was later assessing the answers. And also the experience of participating in interviews could be beneficial. Here, it's important not to assess the level of knowledge as such, but it's also about discovering what the life principles of a person are. And the most important things that we can discover during interviews are the motivation that the person has, why they want to apply for this or that position, what they want to accomplish. So the availability of this motivation is about goodwill. It's about a person understanding that they will have the duty once they will be appointed, that they need to make the decisions independently of the circumstances or their own desires. So it's really important to identify whether the person has the right motivation during the interview stage. So I think this experience will be beneficial. And what is my most important contribution is that I have the experience of assessing people. Because here you need to have an understanding that the trust of the society in the judiciary depends on the quality of justice served by the judges. There are some norms that have been declared in the Constitution. Something is also mentioned in the law on the judiciary and the status of judges, but we don't have the mechanism for holding judges accountable if they don't perform their duties in the right way. If they have some cases that have been adjourned and they don't do anything about that. So the society is expecting that this judge is punished or that there is some kind of accountability. Why are they not doing anything about such cases? So I have some level of understanding about these questions, and that is why I've applied for this selection. I know how we can identify those violations. I know how judges can conceal some of their violations. I know how they are trying to hide such things.
Ms. Olenenko, you have a number of interesting suggestions for strengthening the assessment process. Do I understand you correctly that you would somehow introduce into that process more consideration of the qualitative analysis that a judge gives to his or her cases? Am I misunderstanding you, or is that a fair summarization of what you propose to do to increase the qualitative analysis of opinions?
I intend to assess all those quantitative indicators in the context of the performance of a judge, of the quality of their work. how diligent they are about their duties, and in such a way maybe to enhance trust in the judiciary. So this is what the society is expecting. This is what our foreign partners are expecting of us. And this is what will be expected by our soldiers who will come back home from the front lines, who will return to peaceful life. My participation in the selection shows that I understand the challenges that we are facing as a society today. The heads of the judiciary must undergo this transformation so that when the soldiers come back home, they don't want to do something with the judges. Our society has matured enough for this transformation, and it's important that it's done on a high level. And we need to factor in the indicators of cancelled decisions, and for that purpose we need to change just two simple words, where the HQCJ takes into account the explanation of the judge. We need to take out these two words, the explanation of the judge, and replace it with the word norms, with permissible norms. So it has to be a civilized way so that the judges are not being thrown out into trash, both figuratively and in the direct sense.
But I understand the work that you've done over the years in statistical analysis, and that's what I would consider, as I think you would too, to be quantitative analysis of what a judge in a court does. What are you talking about in terms of qualitative analysis? You earlier mentioned their effectiveness at reaching amicable results and mediations. Are you thinking about opinions in any way, or is that quantitative analysis where you simply look to see how often they've been sustained or reversed by the appellate courts?
I was summarizing court practice based on categories, so I have this kind of experience. But I believe it is possible in the future that within the work of HQCJ, we, together with scholars and representatives of the Supreme Court using AI, will be able to see what specific norms of law are typically applied for this or that type of cases or disputes. So we can rely on the level of digitalization that we already have in the country. So it can be used in the work of HQCJ. And then together with the National School of Judges, we can channel these efforts to enhance the qualification of judges, to improve the quality of their work. So this is quite an interesting direction.
Can I ask you one more question, please? If you followed our hearings over the course of the past number of weeks, you'll know that sometimes we feel it necessary to ask questions about family members. Let me do that right now, if I can, for a second. You were divorced from your husband, as I understand it, in 2015, yet you continue to list him in your assets declaration, even at least as late as 2021. Is that correct? Why is that, first of all?
I'm indicating him in the section other relations, since he is the co-owner of the apartment where I'm living together with my child. So we got divorced, but he still has a share in the apartment. He is the co-owner. So we had this deal So he left the apartment to me and the child, and he left this marriage driving an expensive car. So we didn't go to court to divide our property.
So it's-
And here we should pay attention to two aspects. Number one, I didn't want to make a dispute out of that, so I wanted to regulate all the property issues without making it public, without having any kind of scandal. So I wanted to do everything in a civilized way. And the other thing is that we are both lawyers, and at the moment we understood that we needed to act in the best interest of our child.
Well, can I get to the crux
We-
of my question?
We didn't want to upset her more with our divorce, so we kept the apartment not to move to another place, not to transfer her to a different school. So we did that in the best interest of our child.
Let me please get to the crux of my question concerning your relationship with your husband. I don't think I'm telling you anything that you don't know when I say he has a very controversial political background. Is that a fair statement? Is that something that preceded your divorce, or is that something that's generally developed only since that divorce was finalized?
When we got married, he was a lawyer at a big firm. But then he started providing the services of a lawyer and attorney at law within elections campaigns. And then he ran for the office himself. And it was one of the reasons for the divorce, because there were multiple reasons, but that was one of those. And my political neutrality is really important for me because, as you can see, I've worked at one court for 23 years, and I intended to continue working at that same court. And then I wanted to become a judge. That is why my political neutrality is really important for me, and it was important back then. I didn't want to be associated with the personality of my husband.
And you have not been associated.
And I think I paid a high price for my political neutrality.
And you have not been associated. Can I stop? You've not been associated with that party, is that correct? You've not been associated with the party in question.
Yes, it's important for me. Since the year 2014, it was very important for me not to be associated with it.
Okay, thank you, Ms. Olenenko. I appreciate it. My colleague, Judge Verlanoff.
Thank you. Thank you, Stephen. Svitlana, so you are referring both to your experience of working within the selection commission, the selection of civil servants, and you mean the selection of people to the court where you're working. Could you please tell us what criteria did you use to assess the candidates during the selection? Could you please enumerate them? The most important thing for me is the professional competence. What other criteria did you take into account? Ethics, relations with the other members of the staff, and integrity. How did you... Yes, thank you. How did you assess integrity as a criteria? On the ground of what documents? What was proof of a person having integrity or lacking it? On the level of HQCJ? No. I'm not asking you about HQCJ. I'm referring to the level of the selection commission that you were a part of. We are not talking about HQCJ. So we analyzed the documents that were submitted by candidates. And we also asked questions during interviews. It's also possible to get some information from social media, from the internet. It's possible to see what priorities the person has, what they are associated with, what their name is associated with when you are searching their name on the internet, whether these are some scholarly papers or just a picture showing them having a rest or vacating somewhere or eating something at a restaurant. That is really important. It tells us a lot about their attitude towards life. Thank you, Svitlana. That's clear. Now let's assume you've been elected as a member of HQCJ and you are assessing the integrity criteria. So, regardless of whether it's a candidate judge or an incumbent judge, in what way are you going to be checking their integrity? Will you be using the presumption of integrity or the presumption of non-integrity? Do you understand my question? It's a very difficult question. Yes, I understand it, but it's a very difficult question for me. Why is it difficult for you? Do you lack the experience to do this kind of assessment, or is it something else? I understand your question. Integrity is about assessing all the available declarations of a person who wants to become a judge. It's not just the tax declaration, but it's also the property declaration where you need to indicate your relatives. And if you lie on your declaration, then in the future we will see that there will be lies in other documents. If there is some inaccurate information about family members, and you, dear commissioners, also paid attention to my declaration, some people may not indicate that they are actually cohabiting with another person. So I think this is the criteria that I will be applying when reviewing the documents of the individual who has submitted it. Thank you, Svitlana. I am passing the floor to our chair. Svitlana, if we summarize your professional background and the selection in which you are currently participating, in case you are appointed as a member of HQCJ, you will have a leap in your career, quite a good one. And some people may say that the head of some division of a court, from the professional point of view, is not a person who can be appointed as an HQCJ member. What would you respond to people making such statements, if you were to hear anyone saying this? what is important here is the professional reputation of a person. I think that I'm a public figure. I have a person whose opinion is quite sufficient. Maybe I don't have the best public speaking skills, but I'm more eloquent in writing. That is why I have different publications, which you can find. And I research everything that I include in my papers and articles, so every word matters. That is why I think somebody who has high professional reputation can be a candidate for HQCJ, and it's also important to want change. I want qualitative changes in the judiciary, because this is the demand from the society. The society is expecting it. I have proposals and I have this great desire. I have a strong motivation to complete such changes, and I'm very surprised that some of the candidates are saying that they don't want to change anything, that they are happy with the situation as it is. And I don't regret applying for this selection. Yes, indeed. I used to be head of the division at a local regional court, and should I be appointed, it's going to be a leap in my career, but I didn't have a chance for self-fulfillment on the position of a judge, even though I tried. Yes, thank you. That's enough for this question. And now let us discuss stereotypes, because my first question was also about stereotypes to a degree. So there are many stereotypes surrounding the Ukrainian judiciary, and the majority say that the judiciary is corrupt, not independent, and imperfect. So what is your suggestion? How should we change these stereotypes? And do you agree that these are actually stereotypes? I absolutely agree with you. These are stereotypes. And mass media is contributing to the formation of these stereotypes. The way in which they are presenting information is incomplete. They are covering only some bad cases, some negative experiences, cases involving notorious people or government officials and authorities. But we should at the same time highlight other types of cases. Information should be objective. So we need to take measures, timely measures, to counteract the formation of these stereotypes. But it also depends on each particular judge. It's not a kind of a mechanism that works on its own. Every judge is an element to this system. If a judge works at some small town and during a court hearing they fall asleep, and we have this attorney at law who is quite of a senior age, and they are watching this judge who has fallen asleep. We've had these cases. We know that it does exist. So I'm saying that every judge is the face of the judiciary, the face of justice. And they all contribute to the general picture, to the general view. Yes, thank you. So on the one hand, you're saying it's a stereotype, but then on the other hand, you're talking about the need for change. Don't you see a certain contradiction in your own position? All these things are interconnected. I'm saying that every judge is forming these stereotypes by the way they act or behave. Having had these episodes in their life, they contribute to the stereotypes. Yevhen, I'm passing the floor to you. Thank you, Mr. Chair. Svitlana, so we are coming to the summary of your today's interview, but I still have some additional questions which have come up throughout our discussion. So, while talking to my colleague Stephen, you've mentioned twice that there are people or forces that are aimed at throwing judges away like trash. So, in a democratic society, do you think it's possible to impose physical punishment on a judge for the decision they have made? No, absolutely not. So why are you stressing upon this episode of some judges being thrown out into trash bins? So do you have this first-hand experience? No, I've heard about this from the news. Thank you, that's clear. While answering Robert's question, you said that should there be any offer coming your way, you would go to the High Council of Justice to report influence. Yes, yes, absolutely right. Do you have any documented proof about reports made to the High Council of Justice? Because you've mentioned that a judge you were assistant to has made such reports. Why am I stressing upon that? Because you were working as assistant judge between 2002 and 2007, and there was no High Council of Justice back then, and there was no way to report to the High Council of Justice. That's why I'm asking you. As far as I know, maybe I'm mistaken in the report being made to the High Council of Justice, but I do remember that the judge reported to a relevant authority, and I think that it's correct. I was mentioning this instance as the correct behavior, yes. You talked about this as some fact, but you don't have any documented proof of that. You have not provided us with any documented proof. We have some evidence that after the start of the full-scale invasion, you left the territory of Ukraine and you crossed the Ukrainian-Hungarian border. Are you still staying abroad? Yes, I'm still staying abroad, but I can return to Ukraine as soon as possible. And where are you staying at the moment? And what is your status? If it's safe to say, I'm currently staying in Italy, and I have the status of a refugee, but I'm not using any programs for refugees because my relatives offered me accommodation, and I cannot afford to use the benefits intended for people who have lost their homes. So in one of the reference letters provided by a priest, you are characterized as an honest, just person, so this recommendation is very positive. And at the same time, he mentions that you are making donations to the parish. So could you tell us more about those donations? So the church is located near my house. It's rather small. It was built quite recently, and it's an open field near the church. So what I was doing, I was buying flowers and planting it in front of the church. So we are not talking about some monetary donations. Those were flowers. Yes, thank you. Mr. Chair, do we have any questions?
Nothing further.
Dear colleagues, any questions? Svitlana, your interview is coming to an end. And the Commission is giving you the floor for some concluding remarks. You're welcome. Thank you. Participation in this selection is an opportunity for me to reach a higher level in my career, and I do support the improvement of the quality of the judiciary, which starts from a good and quality selection procedure and will result in the quality work of judges. And having a democratic society means that we have judges with integrity. We need to have control over the quality of the work of judges. That is something that I intend to do as a member of HQCJ should I be appointed. And I'm asking you to select people who are agents of change, who are motivated to have quality judiciary in Ukraine. That is something that the foreign partners and the Ukrainian society are expecting. And that is also something that those 8 million Ukrainians who have left the territory of the country are expecting. I have not met a single person who would not want to return back home. Yes, we all want to go back home, but we want to live in a democratic country. That's why I wish you good luck in selecting agents of change, people who wish the best for Ukraine. Thank you for giving me this opportunity to participate in this selection. I wish you all good health, and I wish us all quick victory. Thank you. Thank you. So this is the end of your interview. Take care and goodbye.